Greetings to panel members and all participants. This webinar, Voices Under Pressure, Defending Freedom of Expression for Lawyers and Journalists, is jointly organized by the CLA, the Law Society of England and Wales, and the Commonwealth Human Rights Institute. My name is Stephen Thiru. I am the CLA President and your moderator today. I wish you a warm welcome and thank you for joining us from across different time zones. Your attendance and participation in this discourse today is truly appreciated. We have on record over 3,280 registrations for this webinar, which in itself underscores the significance of the topic for discussion. Today also marks a launch of a collaborative research on the right of lawyers to freedom of expression, grounded in international legal standards, including the UN Basic Principles on the Role of Lawyers and the Council of Europe's new Convention for the Protection of the Profession of Lawyers, and a report on defamation laws across the Commonwealth. We will launch Who Controls the Narrative? Legal Restrictions on Freedom of Expression in the Commonwealth, quote unquote, a joint initiative of the Commonwealth Human Rights Initiative, the Commonwealth Journalists Association, and the CLA, highlighting how laws have been misused to curtail media freedom. I wish to also here acknowledge the important work of the CLA's Rule of Law and Human Rights Committee, whose conveners are David Green and Sophie Stanbrook. Ladies and gentlemen, under Principle 23, of the UN Basic Principles on the Role of Lawyers, it is provided that lawyers are entitled to freedom of expression and have the right to take part in public discussions or matters concerning the law, administration of justice, and the protection of human rights. And in the exercise of these rights, lawyers must conduct themselves in accordance with the law and recognize standards and ethics of the legal profession. The recently passed Council of Europe's Convention for the Protection of the Profession of Lawyer requires, under its Article 7 or Paragraph 7, European governments to ensure the right of lawyers to participate in public discussions on matters concerning the administration of justice, access to justice, and judicial decisions. This webinar will explore the existing legal frameworks and the disciplinary measures which are sometimes weaponized to silence lawyers and journalists around the world from discharging their functions and exercising the fundamental right to freedom of expression. This is an important opportunity to examine global patterns of repression, shared insights on legal protections, and to strengthen advocacy for those who defend human rights, access to justice, and the rule of law. Why does today's discourse matter to all of us? George Orwell, in the preface to his famous book, Animal Farm, said, and I quote, if liberty means anything at all, it means the right to tell people what they do not want to hear. Unquote. Freedom of expression was recognized by the United Nations as a fundamental universal right in 1948. Today, lawyers and journalists are frontline defenders of rights, justice, and accountability. They increasingly face harassment, intimidation, disbarment, being struck off the rolls, and prosecution simply for doing their jobs. Outdated or vague laws, such as sedition and national security legislation, are often weaponized. The gap between international principles and real-world practices is ever widening. There is a marked erosion of the rule of law and fundamental rights, particularly the freedom of expression. Our discussion today will include how legal frameworks and disciplinary measures are weaponized to silence lawyers and journalists around the world simply for doing their job. This presents an important opportunity for all of us to examine global patterns of repression, share insights on legal protections, and strengthen advocacy for those who defend human rights, access to justice, and the rule of law. We have assembled today for you a panel of speakers, a distinguished panel of speakers who all really need no introduction. We will start with our first speaker, and our first speaker is Deborah Long. Deborah is the International Policy Manager for Rule of Law and Human Rights at the Law Society of England and Wales. The Law Society will be publishing a report titled, quote, "When Lawyers Are Silenced, How Restrictions on Lawyers' Expression Undermine Rights, Justice, and Democracy," unquote. The report examines the widespread and concerning trend of curbs on lawyers' freedom of expression, a right fundamental to the rule of law and access to justice. I invite you, Deborah, to be our first presenter this evening. Thank you.
Thank you, Stephen, for the kind introduction, and thank you everyone for joining today. The Law Society of England and Wales is the independent professional body for approximately 200,000 solicitors. For 200 years, we've been run by and for our members to promote the value of the profession, defend the justice system, and support lawyers in their work. Around the world, lawyers play a vital role in upholding the rule of law. They protect access to justice, challenge abuses of power, defend individual rights, and safeguard the independence of the profession itself. Yet precisely because of this role, lawyers often face harassment, intimidation, or interference, as Stephen mentioned, simply for doing their job. So in solidarity with colleagues around the world, the Law Society runs the Lawyers at Risk programme. This initiative advocates on behalf of lawyers who face human rights violations because of their work and aims to protect the independence of the legal profession globally. We intervene in many ways. We send letters of concern to governments, issue public statements, conduct advocacy before the UN and regional human rights bodies. And we also sometimes take part in trial observations and fact-finding missions, just to name a few of our actions. Through this work, we've seen a deeply troubling trend. Lawyers are increasingly being silenced when exercising their right to freedom of expression. Across all regions, lawyers face disciplinary sanctions, harassment, threats, and even criminal prosecution when speaking out. As Stephen mentioned, to draw attention to this issue, we will soon be publishing a thematic report to highlight the risks that lawyers face when speaking out. Our report, When Lawyers Are Silenced, How Restrictions on Lawyers' Expression Undermine Rights, Justice and Democracy, is timely. The report draws on real cases, including that of Kevin Yam, who I'm pleased is joining us today, and highlights a very disturbing global pattern of interference with lawyers' freedom of expression. In this report, we've identified three main categories of laws being used against lawyers. First, there are laws designed to restrict freedom of expression, perhaps legitimately, but applied arbitrarily, such as laws on sedition, criminal libel, or insulting language. Second, there are counter-terrorism or national security laws, which often include overbroad and vague offences, carry very severe penalties, and attract restrictions on fair trial guarantees. And the third category are laws, regulations, codes, and conduct governing the legal profession, where disciplinary measures and disbarment are misused as tools of control. These are all legal means serving illegitimate ends. Freedom of expression is a cornerstone of any democratic society, and as Stephen mentioned, is recognised as such under international law. It enables people to speak out, to share ideas, to challenge power, and to push for change. As Fijian lawyer Richard Naidu, who himself faced action when speaking out, has said, freedom of expression is not just a principle, it is socially efficient. It allows society to listen, learn, and take remedial steps. For lawyers, this right is particularly critical. It is the basis on which lawyers conduct themselves in court, advocate for legal reform and human rights, speak out against injustice, and educate the public on legal issues through public statements, media, publications, and social platforms. When lawyers are prevented from speaking freely, the rule of law and institutional independence are weakened. Lawyers are a key check on state powers, and their voices are essential for accountability. Therefore, while, like everyone, lawyers benefit from the general protection of this fundamental right, international human rights law has gone further by explicitly safeguarding their freedom of expression. Stephen, in his introduction, mentioned the protection affirmed in Principle 23 of the UN Basic Principles on the role of lawyers, and this has now been reinforced by Article 7 of the new Council of Europe Convention for the Protection of the Profession of Lawyer. This right has also been consistently upheld in the case law and findings of UN bodies, as well as regional human rights mechanisms. Now, of course, the right is not absolute. Lawyers may face restrictions where these are lawful, necessary, and proportionate. In addition, their professional obligations can justify certain limits on expression. For example, to safeguard client confidentiality or to avoid prejudicing the fairness of a trial. But what we see is far too often restrictions go well beyond what international law permits and are used to silence dissent and curtail justice. One current example is Turkey. The leadership of the Istanbul Bar Association has been targeted after posting on social media about the deaths of 2 journalists in Syria and calling for the release of detained protesters and lawyers. In January this year, a board member of the Istanbul Bar was arrested after returning from an advocacy trip to visit the Council of Europe, and he was charged with terrorism-related offences. He spent 4 months in pre-trial detention, but was then subsequently released. Then, in March this year, a court moved to remove the elected leadership of the bar, while the president and 10 board members were charged with making propaganda for a terrorist organisation and spreading misleading information. Under these charges, they could face up to 12 years in prison, and their case is ongoing. Cases like this show how restrictions on expression not only harm individuals, but ripple across the entire profession. For those directly targeted, the consequences can be devastating: loss of livelihood, loss of liberty, and of course, immense personal and family hardship. But beyond the individual, such actions create a very chilling effect. Lawyers may avoid controversial cases or refrain from speaking out altogether for fear of reprisal. This climate of self-censorship undermines open debate, legal reform, and government accountability. So silencing lawyers is not simply an attack on individuals, it is an attack on justice, democracy, and the rule of law itself. Accordingly, states, international institutions, and legal professional associations all have a role to play in ensuring that lawyers can carry out their professional duties without fear of reprisal. Therefore, in our forthcoming report, we make several recommendations for actions at all levels. Just to name a few, this includes a review of laws to ensure they comply with international standards on freedom of expression, the repeal or reform of vague or overbroad provisions that can be abused, and of course the immediate release of lawyers detained for their expressed views. We also urge strong and coordinated international action to condemn attacks on lawyers and to ensure that they can carry out their duties without interference. So to conclude, the message is simple but vital. When lawyers' freedom of expression is protected, societies are better equipped to secure justice, defend human rights, and maintain public trust in institutions. Thank you. I'll hand back to Stephen.
Thank you, Deborah. Thank you very much. If I may quote you, silencing lawyers is an attack on justice, the rule of law, and democracy. I think that very much sums up the central purpose of the discourse that we are having today. And I'm sure you'll also have questions about the upcoming report that the Law Society is going to publish. And we'll save that for the question and answer. I'd like to move on now to our second speaker. Again, another person who requires no introduction. With her permission, I would like to keep her introduction brief. Sneh Arora is an international human rights lawyer and director of the Commonwealth Human Rights Initiative, CHRI. CHRI focuses on a range of human rights themes, including freedom of expression and media freedom. Sneh's legal research and policy work has contributed particularly to the CHRI's recent report, which is being launched today, entitled Who Controls the Narrative? Legal Restrictions on Freedom of Expression in the Commonwealth. Sneh.
Thank you. Thank you, Stephen. Good morning, good afternoon, and good evening to all of you joining from across the Commonwealth and beyond. It's a very big honor to be here with you at this important event, Voices Under Pressure, and I want to warmly thank the co-organizers, the Commonwealth Lawyers Association and the Law Society, as well as our moderator for bringing us together today. At the outset, I would like to acknowledge the many brave journalists and lawyers and activists, some of whom are on this panel and many in the audience, who are working under extraordinarily difficult conditions to defend the truth, to protect rights, and to uphold the rule of law. You are quite literally on the front lines of freedom. So we're here today to talk about freedom of expression, and I'm here to proudly, with a great team of contributors, launch our report, Who Controls the Narrative, which examines the legal restrictions on freedom of expression in the Commonwealth. So we're here today to talk about freedom of expression, and more specifically, the growing forces that are eroding it across the Commonwealth. So let me be clear, the right to freedom of expression is under serious threat in every region of the Commonwealth. This is not about censorship, it's about control. It's about shaping public narratives, suppressing dissent, and instilling fear. Across the Commonwealth, we are witnessing an incredible misuse of criminal laws to punish speech. And I say misuse deliberately because many of these laws were never designed to protect people. They were designed to protect power. Many of them are holdovers from the colonial era and urgently require repeal or reform. Here are a few sobering highlights from the report's Commonwealth Highlights section. More than 80% of Commonwealth countries still retain criminal defamation laws. At least 20 have sedition laws on their books. 13 countries have laws still that criminalize blasphemy. And a growing number of Commonwealth countries are turning to cybercrime and national security legislation to arrest journalists, activists, lawyers, and ordinary citizens who are posting online. So these are not abstract legal provisions. These are being used against real people. And as Stephen and Deborah have already outlined, these are being used to stifle debate. There are so many cases I could highlight of journalists being detained without bail for posting on social media, for being held in solitary confinement, for criticizing the ruling elite, who are being targeted with defamation suits. There are women journalists and LGBTQ plus activists being harassed, threatened, and criminalized under vague or discriminatory laws, targeted not only for what they say, but for who they are. There's so many cases, there's so many stories, but no doubt we will hear about these stories directly from those who have lived it, from those other members of our panel. And these are not isolated incidents. They are part of a deliberate pattern across the Commonwealth to use law as a tool of suppression. But yet, amid this sobering reality, there are moments of hope, proof that persistence and advocacy can lead to change. Just last month in Bangladesh, the Dhaka Cyber Tribunal dismissed a long-running case against human rights defender Shahidul Alam. He's a renowned photojournalist and activist. He spent more than 7 years facing charges under the Information and Communications Technology Act simply for publishing a report that he was investigating. He was detained for over 100 days and for speaking out on violence. So he eventually was acquitted, and this acquittal is a powerful reminder that change is possible. Cases can be dismissed, laws can be repealed, repression can be rolled back, and reform is within reach. And that brings me to the reason we're here today. This report, Who Controls the Narrative, is the result of over a year's work by the Commonwealth Human Rights Initiative, along with our partners, the Commonwealth Journalists Association and the Commonwealth Lawyers Association. It examines the legal and policy frameworks governing freedom of expression across all 56 Commonwealth countries. It focuses on constitutional protections and limitations. It focuses on criminal defamation, on sedition, on blasphemy, national security and anti-terrorism laws, cybercrime, and the misuse of licensing and regulatory powers to restrict independent media. Now, what makes this report unique is that it doesn't stop at analysis. It provides a clear roadmap for reform. Our findings are based on detailed legal research, over 80 expert contributions, and responses to questionnaires by journalists, by lawyers across the Commonwealth. There are regional analysis, so the analysis of the legal frameworks are divided by region, as well as spotlight case study stories that add breadth and depth to the issues. So we have, I would share my screen, but I don't think I can share my screen today, which is unfortunate. But I would show you, I'll try to show you at least the cover page at the end of my talk. So the report findings, I want to talk a little bit about that. They reveal that despite some variation across the countries, there are certain trends that are really disturbingly consistent. States have typically used vague and broad legal terms, such as false news, such as obscene, offensive, or anti-national. And these broad legal terms are used to prosecute free speech. SLAPs, strategic lawsuits against public participation, pretrial detention of women journalists and LGBTQ activists. These tools are also being used to suppress voice. Charges are being used to intimidate and exhaust defendants, even when they're later acquitted. Even the threat of a lawsuit, as Deborah mentioned, can have a chilling effect on freedom of expression and public oversight. Online speech is under intensified scrutiny, with new laws criminalizing social media expression. And as mentioned, and worryingly, we see a rise in self-censorship as people fear retaliation for speaking up. But we also found areas of progress. In some countries, outdated laws have been repealed, courts have upheld press freedom, civil society has mobilized to demand reform. So what we need now is for governments to act. And we need that action to be grounded in the commitments that they have already made. The government meeting 2024 in Samoa, Commonwealth leaders endorsed a major step forward: the Commonwealth Principles on Freedom of Expression and the Role of the Media in Good Governance. Commonwealth heads urged Commonwealth member states to ensure their effective implementation. Now, these media principles developed through sustained civil society advocacy over years, and CHRI, the Commonwealth Human Rights Initiative, the CJA, the Journalists Association, and the Lawyers Association were part of this incredible push. These now adopted principles offer a clear framework for reform. For example, Article 2 calls on member states to repeal or amend laws that unduly restrict the right to freedom of expression and to align national frameworks with international standards. But they go further than that. Article 7 recognizes the right of journalists to gather, access, and disseminate information without interference. Article 8 commits governments to ensure transparency, independence of media regulators, and protections against political or commercial influence. So the adoption of the media principles is a marked milestone. It's an important milestone. But let's be honest, we know that words are not enough. What's needed now is implementation. So our report, Who Controls the Narrative, is designed to support the next step of implementation. It sets out several key global recommendations, which I'd like to briefly highlight. I know time is ticking for all of us. I'd like to briefly highlight some of the global recommendations. One is repealing criminal defamation laws. Criminalizing defamation is neither necessary nor proportionate. Civil remedies are available and far more compatible with international human rights standards. Second, abolish sedition and blasphemy laws. These laws tend to be vague, overbroad, and frequently used to target dissenters, religious minorities, and critics. Amend national securities and cybercrime laws. These laws can also be narrowly defined, clearly, they must be narrowly defined, they must be clearly drafted, and they must be subject to judicial oversight. They should not be used as tools of political persecution. Strengthen judicial independence and due process safeguards, and also to guarantee access to information and independent regulation of the media. These are not radical proposals. There's more detailed information in our report about each of these global recommendations that I invite you to take a look at. These are not radical proposals, as I said. They are practical steps that member states can and must take. The report also includes regional level recommendations, each tailored to the legal and political context of each Commonwealth region, Asia, Africa, and the Pacific. So in conclusion, where does this leave us? As we launch this report today, I invite not just reflection, but action. To the lawyers in this audience, use this report as a tool for litigation, policy engagement, and legal education. To the journalists, let this remind you that you are not alone. Your voice matters. Your courage matters. To civil society, continue to build alliances. Continue to push for reform. Challenge the misuse of law, because silence only emboldens repression. And to governments and institutions across the Commonwealth, you have made a commitment. The media principles, now act on it. Align your national laws with international standards. Protect journalists and the media. Uphold open debate. Honor the spirit of the media principles. Because at the end of the day, freedom of expression must be more than just words on paper. It must be realized in law, protected in practice, and upheld with courage. Thank you.
Thank you very much, Danae. Again, another comprehensive report, like the report from the Law Society of England and Wales, which gives us a good landscape of where we are in terms of freedom of expression, whether it's for lawyers or for journalists. And the chilling message that we get is that there is erosion all around, and this erosion is worrying. But there are, there is a light at the end of the tunnel. And I like to think that the Commonwealth principles, the media principles, is a good example. And I'm glad that you mentioned that, because I've always felt that governments that have signed up to it must be held to account. It cannot be a matter of doing the politically right thing while you are in Samoa, and then when you go back to your own jurisdiction, it remains just a paper in a book that is kept there. Somebody must ask, what have you done? Having signed up to this, what have you done? What steps have you taken to bring that promise to being in your country? And we know, and it's mentioned, I think it was mentioned by Deborah, that at least in 30 of the Commonwealth countries, we still have sedition laws. And sedition laws, for those who are not familiar with sedition laws, they are strict liability offenses. Intent and mens rea are irrelevant insofar as the words are uttered, and they're considered to have what is known, I think, generally as seditious tendencies. That in itself is enough to secure a conviction. And what has been done since Chogam in Samoa? I think that's a burning question that we should ask. And if there's any takeaway from this webinar today, we must be resolute in asking our governments to account for what they have signed up to. Now, we've heard these two studies, and which gives you a good broad sweep the landscape of where we are in freedom of expression, it's time now to listen to real-life examples. Lawyers, journalists who have exercised their right to freedom of expression, and then they have been sanctioned, penalized because of that. I say no more, but let me just take the first speaker. We have Kevin Young. Kevin is a qualified solicitor from Hong Kong, and he qualified in 2005. And he was for many years a rule of law and democracy activist in Hong Kong. He gave testimony before the United States Congressional Executive Committee on the implication of China's national security law on Hong Kong. And as a result, Kevin was struck off recently from the roles as a solicitor. Kevin, good to see you, Kevin. How are you?
I'm good, thank you, Stephen, and thank you thank the Commonwealth Lawyers Association, the Law Society of England and Wales, and the Commonwealth Human Rights Initiative for inviting me this evening.
All right. Would you like to tell us, Kevin, what did you speak about at the congressional hearing? I believe it's in 2022 or 2023, was it?
Yes, it was in May 2023, by which time the Hong Kong national security law had been in place for well over two and a half years. And by that time, in fact, a number of lawyers had already been locked up or otherwise prosecuted. And in many ways, one of the reasons why I ended up giving that testimony is because I was living in Australia. I wasn't under any immediate legal threat from Hong Kong at the time. And I was kind of like the last person standing who can talk about these things. And so I gave testimony both in written and in oral forms. The written form was heavily footnoted with all sorts of references justifying my assertions, talking about the erosion of the rule of law in Hong Kong, the political persecution of dissidents, including lawyers. And as part of my testimony, I called, with some reluctance, I must say, for the consideration of international sanctions against legal profession participants who really made it possible for the persecution and the crackdown in Hong Kong to happen, including certain national security prosecutors, and in one reference to national security judges. Now, I did not make those calls lightly. I know that in a democratic society with well-recognized rule of law, such calls would be considered controversial. However, we are in Hong Kong, and after much reflection and consideration, I considered it to be a situation where we already have a number of leading human rights lawyers locked up. We have a number of other human rights lawyers who have been silenced through prosecution and other threats. And the Hong Kong authorities and leaders of the Hong Kong legal fraternity were not willing to speak out or do anything about it. And so I saw my call as a bit of a last resort. Now, unfortunately for me, but it's small discomfort compared with those who are in jail in Hong Kong. I ended up firstly having a 1 million Hong Kong dollars, which is around 95,000 pounds, bounty put over my head by the Hong Kong National Security Police in July 2023. And ever since then, I've been harassed in all sorts of ways, whether it's in the form of leaflets being dropped around Melbourne, where I live, asking that I be kidnapped back to Hong Kong, or in the form of Hong Kong tax authorities raising spurious tax demands from taxes from 5-6 years ago against me, or as we're talking about now, in the form of disbarment proceedings against me, which ultimately led to my disbarment. I did not contest those proceedings for the obvious reason that, in a way, what's the point? It's a lot like a lot of those national security law defendants in Hong Kong who chose to plead guilty. So rather than wasting time and further costs in my life, I thought might as well bring it to a quick conclusion.
What happened, Kevin? You were sanctioned by the Law Society, I think the disciplinary board.
Yes.
What was the charge against you? And it was obviously centered on you speaking at that hearing. And as we understand it, as I understand it, you were speaking about the rule of law being violated, as you saw it, in terms of the national security law, particularly, and the way in which it was applied, the implications that it had, and your concerns about it. So, it's like, well, all of us lawyers, we speak about rule of law violations quite often, right? And we would obviously then focus on particular laws, not in general terms, and I will express our concerns. And in where I come from in Malaysia, we would talk about the Sedition Act, and we would point to parts of the act, as Sneh mentioned, which uses very ambiguous terms, but which carries very harsh sanctions. So in your case, what was the charge that was leveled against you for having spoken up for these rule of law violations as you saw them?
Yes, thanks for the question, Stephen. I was charged with conduct unbecoming of a solicitor in Hong Kong. And the allegation essentially is that by giving that testimony and calling for sanctions in the way that I did, I was bringing disrepute to the legal profession in Hong Kong, and it impaired my integrity. In my view, I reject those allegations because, if anything, I was speaking out at the time because I cared a lot, and I still care a lot, about the rule of law in Hong Kong and about the exercise of fundamental rights in Hong Kong. And the Law Society of Hong Kong tries to paint this as an open and shut case of, a scandalous lawyer calling for sanctions against prosecutors and judges. But to look at that in isolation without looking at the national security law crackdown to which I was testifying and the lack of action from the Hong Kong authorities and leaders of the legal profession there is, in my view, unfortunate, but I'm not here to be, beating the Law Society of Hong Kong for it. I know that they're under pressure too.
No. So it's not about that really. I think it's important that and I'm happy you said that, because we want to focus on the principles that are at stake here, and those principles are important principles, and those principles are universal principles that deserve protection across jurisdictions, and really there are no differences. We can't be splitting hairs on them. So we're clear on that. Here, and if you look at even Principle 23, when we speak about the freedom of expression that lawyers have, we are at the end of Principle 23. There is, of course, a reminder that in exercising that right, it must be in accordance to law, and it must be in accordance to recognized standards and the ethics of the legal profession. So I suppose the Law Society found that this was an ethical breach, and that was the thrust of the charge against you. Ethical breach for having spoken out on violations of the rule of law.
Yes, and I guess it's not just that, it's also that I call for those who are, especially those in the legal profession, who are involved in all this, to be held accountable for it. And because there is no domestic accountability mechanism available now, that's why I went international with it.
Yes. And I think the common answer to the national security legislation, China's national security legislation for Hong Kong, is that it is not just Hong Kong that has it, that China has it for Hong Kong. Every country has national security legislation, and the laws are there, and it's quite unfair to just target Hong Kong for these laws. What would you say to that?
I would say two things. First of all, of course, Hong Kong, and for that matter, China, are not the only jurisdictions in the world with draconian national security laws, which lawyers around the world are concerned about in terms of their rule of law implications. As for countries or jurisdictions which are recognized as having strong rule of law, but nonetheless have national security legislation, they are often subject to a whole lot of human rights and procedural safeguards. And when I talk about procedural safeguards, I do not just mean the formality of a process of looking like you're giving someone a fair trial, but actually ensuring that lots of hoops are gone through before people are prosecuted or even investigated. There are lots of restrictions on how those laws can be applied insofar as human rights standards are concerned. In Hong Kong, all of that have been overridden. And in fact, the national security law makes clear that if there is any conflict between the national security law and the basic law of Hong Kong, which contains a whole bunch of human rights guarantees, the national security law is to prevail.
Thank you, Kevin. I'm sure there'll be questions for you from our participants. And I'm sure many of them are very concerned about what has happened to you, because this could very well be a textbook case for many of them, for many of us in other jurisdictions who speak out openly, and then find that for some reason our practice and ethical rules, our ethical obligations are expanded, and you face sanction for that. So I'm sure those concerns and anxieties would be raised, and to you, and you could answer them. Now, can we move on from a lawyer perspective? Now we look at a journalist. We have Neha Dixit. Neha Dixit is an independent journalist and author based in New Delhi. Her work focuses on the intersection of politics, gender, and social justice. She has investigated and exposed a wide range of human rights violations, and her work has earned over a dozen awards, including the International Press Freedom Award. Neha, good to have you. How are you?
Good. Thank you so much. Very happy to be here.
Yeah. So you've heard what I call the real life experience, and really, the heart of our discussion here, leaving aside the theory and the law and the principles that we are familiar with and we want to see applied. You've heard of Kevin's experience. Tell us about yours, the challenges that you have faced as a journalist. And I'm quite sure it's not uncommon. There'll be many journalists here who will be agreeing with you. Tell us the kind of challenges that you have faced in India.
Thank you so much for this question, because I do want to say that I'm speaking from a place where our Prime Minister has not held a single press conference in the last 11 years. And I say this because I do want to insist on the fact that when we are holding governments accountable, we need to also think of whether they're even interested in freedom of speech, freedom of expression. Do they think that press freedom in itself is important for a democracy, and a democracy like India, which claims to be the largest in the world? I do want to say that this is also the time where our cabinet ministers have not just coined but normalized words like prostitute. What Sneh was saying earlier, anti-national is something that we are all anti-nationals, and because we do our jobs. And today is also a day, as we speak, the Supreme Court has actually issued a restraining order on 5 journalists for reporting on a corporate group called the Adanis, and said that it is anti-national. And I say this because, it is this kind of equivalence that if you are even reporting on a corporate group that is close to the political party in power, that's considered anti-national. That in itself is sort of very detrimental to any kind of press freedom that should exist in a country like this. As a journalist, I do want to say that I'm privileged because I write in English and I have class privilege and I live in Delhi. And so, which is why I am still not in jail like many of my colleagues and well-wishers are. I do want to say that for me personally, when we all started our journalism, not just in India, but everywhere else, we were told that, if after a story, if there is if you get a legal notice, it's a badge of honor. So none of us have ever been afraid of, any legal notices. It only means that somebody's reading your report and getting really affected by it. But in the last 10, 11 years, what has also happened is that uh, uh, it's not like any political party is very fond of independent journalists or any kind of independent critique. But what has changed in the last 10, 11 years is the fact that the government has started using law and order related cases against journalists, just the kind of things that you were mentioning. I have 3 criminal cases against me for the last 9 years. And even though I'm not in jail, but every 3 months, I have to travel 5,000 kilometers from where I live to appear in the court. And this has been on for the last 9 years. And the trial still hasn't started. I want to say this. And so, and this seems to be a norm for most people. I had done a story on how Hindu right-wing fundamentalists, how they traffic children from Northeast India and indoctrinate them into Hindutva ideology. And it's a similar pattern that happened to a lot of indigenous children in Australia and Canada. It's the same template that was being used here. So 3 cases were filed against me. 2 are of criminal defamation, like Sneh mentioned earlier, that these are colonial laws and they continue to be used against journalists. And one is of inciting communal hatred. And that case has been filed against me by the Solicitor General of the High Court of that state, and who's also the spokesperson of the political party in power. So why I keep saying this is because there is a huge corporate political nexus that exists in India. So it's no longer a political party in power, but also a corporate political nexus, and which is why a lot of our mainstream media has sort of bowed down to the party in power, which is why if you see even like ministers, now there is a trend. They do not want to give interviews to journalists. They give interviews to influencers. So clearly, what food are you eating, or what clothes, where do you buy your clothes from, kind of questions are being answered by our prime ministers and cabinet ministers, but not real questions about what work have they done. And that is also something that is happening. We've also, in the last 10, 11 years, we've also had a situation where there has been a lot of evidence that tells us that uh, governments and political party in powers have put together a very organized IT cell that not just targets journalists, activists, academics, filmmakers, artists, whoever is critiquing the establishment, as they should, but they also target them in terms of online trolling. So we all have had our pictures. And apart from that, so I want to say that there are legal cases, there is online trolling, but at the same time, there are physical attacks. For instance, I was stalked for 5 months where people were calling me on the phone, identifying which market I was in and what was I buying and which part of my balcony I was standing at, and eventually trying to threatening me that they would gang rape me or throw acid at me, and they eventually try to break into the house. And this happened in spite of the fact that I live in Delhi and I have a lot of privilege. The same sort of situation is and I'm still here talking to you. But something like that is not available to a lot of our journalists in smaller towns, remote areas, villages, and that is where the problem is. I'll give you an example. For example, during COVID 19, the government actually, in the first 3 months, there were 55 cases against cases against 55 journalists for just reporting something as simple as that the government hospitals do not have oxygen cylinders or PPE kits. And for that, cases like Disaster Management Act, Epidemics Diseases Act have been used. We've also in a situation where not just people have been attacked, legal cases, but our governments and particular state governments have actually started using something called the bulldozer. So people who have critiqued the establishment or critiqued the governments has sent bulldozers to their house and razed their houses. So this is the kind of imminent threat that exists right now as I speak. That is something that needs to be taken into account. And also the fact that, this bit about trial not starting. As we speak, a couple of academics, activists have been in jail for the last 5 years without the trial getting started. And that seems to be the norm now and is no longer questioned. And that is perhaps something that we need to look at. Yes, holding them accountable and making sure that they uphold freedom of expression and speech, but at the same time also question whether they're really interested in it or not, because sedition is again something that has been used against reporters, activists, filmmakers, artists. We've had draconian laws like Unlawful Activities Prevention Act and National Security Act, where once you're charged with it, you can't even, for example, if you're once charged under National Security Act, you can't even go to the court. It's the state government or the government that puts together a committee and decides whether you can get bail or not. So though the criminalization of journalism is something that has happened and it continues to be there. A lot of us are still out and not dead or out, but at the same time every month we have a case of journalists being attacked, and there's absolutely no urgency, accountability, or effort on the part of the government to even take cognizance of it.
Thank you, Nia. You must forgive me for my ignorance. I did know that the situation is bad, but I didn't know it was as dire as the way you have put it. And I'm quite sure that it's just not in India. It's just not a threat of cases and having cases hang over your head, which is the most effective tool of harassment. Because there's no landing. You don't get either convicted or acquitted and get into a system, but it just hangs, and so there's uncertainty. That is tremendous psychological pressure and unfair pressure, if I may say so. Is there any move among journalists, the media in India, to come together to take a stand on this? Because it's absolutely awful. I think there's no there's not any other way to describe this. It's awful. Is there any common front among media journalists, or indeed the bar in India, to defend freedom of expression as a universal human right, and which is, of course, what's saved in your constitution, is provided for in an express constitution, a written constitution. You have that right, and there are exceptions. None of those exceptions apply to everything that you have told us. So the right should be exercised, and you should have the full benefit of that right. And yet we hear this pushback, no pushback at all.
There is pushback. The fact that so many people are being attacked or being put behind bars is a testament that people are pushing back, and the establishment can't deal with that. But at the same time, I do want to say that see why I keep saying that there's a corporate political nexus, because a large chunk of mainstream media is owned by the same corporate group that fund the political party in power. So right now, the major news organizations who own TV channels, who own all kinds of legacy media, newspapers, are aligned with the party in power, and so they're not critical. So even when independent journalists, independent news organizations, alternate news organizations, progressive news organizations, with their very small with a limited set of resources, when they come out, they do not have the kind of reach that the mainstream news organizations have. Yes, there is a lot of pushback. Yes, we've consistently tried to hold the government accountable. As we speak, the journalist in 2017, Gauri Lankesh, she was killed in Bangalore, in the main part of the city, and this is the 7th year. We still do not have any conviction. We've had in the last 10-11 years, we've almost had 120 cases of attack against journalists, and there has been 0 conviction so far. This is so there is, yes, journalists who are doing their job. Journalists are always anti-establishment, so they are questioning whoever, regardless of which political party is in power. They're doing that, but that number has gone down. And I do want to say, yes, maybe in the metros and maybe in the bigger cities, we are able to voice out, but at the same time, journalists in smaller places, in villages, where the big corporate media, what they have done is that they only hire journalists as gig workers. So the moment there is a case against them, they abandon them and they no longer support them. And in that situation, how do you even expect any kind of freedom of speech or even having any authentic information in remote areas? So that continues to be a situation.
Thank you, Neha. I think later in the question and answer, we must get into the issue of how there can be international protection where domestic protection is lacking or insufficient for journalists like you who are in peril, undoubtedly, for the wonderful work that you do in exercise of your right, which is in Article 19 of the Indian Constitution, is that freedom of expression, right? Thank you, Neha. Thank you. Right. I like to give some time for question and answer, so I'm going to move on to our last two speakers. Our next speaker, our penultimate speaker, is Margaret Satterthwaite, who is the current UN Special Rapporteur on the independence of judges and lawyers. She is also a professor of law at the New York University School of Law, where she researches judicial independence, access to justice, and the well-being of human rights defenders. She will speak today about the wonderful work that she does, and I'm privy to it. I do read her reports, very detailed reports of the concerns that we have throughout the UN and in different countries, and they are obviously very troubling and worrying. Margaret.
Thank you so much. And I just want to thank all of the organizers for this really important event. Listening to everyone so far has been both riveting and also very, very concerning. So I'm glad that we're all coming together to have these important discussions. I'm just going to start by telling you that I'm getting messages in the middle of the night sometimes. They'll start with a thoughtful, even personal introduction, like, I hope you're doing well, or I hope your children are doing well. And I find really that even at these very, very stressful moments, lawyers are uniformly kind and polite. Once I've acknowledged who the sender is, the tone shifts and it will say something like, I'm sorry to disturb you at this hour, or I write with bad news. As the UN Special Rapporteur on the independence of judges and lawyers, I've shared, of course, my mobile number with trusted bar associations and lawyers in many countries. I feel that it's important to be available to those who are under attack, who want to communicate with me directly. The bad news has included reports of judges imprisoned, lawyers disbarred, imprisoned, or even killed for their work. As Special Rapporteur, I have a mandate to record these attacks, to monitor the progress made in protecting and enhancing the independence of judges and lawyers, and to make concrete recommendations to states and other actors, and to identify ways to improve that independence. So what I can do often feels terribly inadequate to the kinds of attacks we're hearing about, but it does give me a good sense of the kinds of attacks, threats, and reprisals lawyers are facing. And from this vantage point, I want to really take a moment to salute and commend the brave work of lawyers who defend human rights and who protect the rights of not only the journalists like those who are on the call today, but also the rule of law more broadly. And the good news from my perspective is that every day I hear about brave lawyers who are standing up for their clients, whether those are well-regarded or unpopular, to provide advice to those who are making important decisions, whether concerning highly valued companies or crucial family matters, and to defend individuals charged with crimes, no matter how infamous the act may be. And I'm reminded that the free exercise of the legal profession in fully functioning justice systems constitutes an essential feature of any country with the rule of law. The free exercise of the legal profession contributes to the right to a fair trial, the right to ensure access to justice, and the oversight of state power and the protection of due process guarantees for everyone. Lawyers' role in protecting the guarantees of a fair trial are especially important to recall in this context, because such rights can never be subject to measures that abolish or entail their partial repeal. Fair trial rights are that essential to the most fundamental protections, including the right to life, the right to be free of torture, the right to security of the person. The right to a fair trial is a key element to the protection of all human rights and is a procedural safeguard to the rule of law. International standards provide that lawyers should not suffer or be threatened with prosecution, administrative, economic, or other sanctions for any action taken in accordance with their recognized professional duties, standards, and ethics. In addition to guaranteeing access to counsel, international standards on the right to a fair trial also provide that accused persons must have adequate time and facilities for the preparation of their defense and should be able to communicate with counsel of their choice. The Human Rights Committee has found that the availability or absence of legal assistance often determines whether a person can access relevant proceedings or participate them in a meaningful way. But despite that central role of lawyers in ensuring the rights of all, or perhaps because of it, lawyers around the world are facing attacks for defending dissenters, protecting elections, defending the rule of law, and of course, as we're discussing today, advancing and defending freedom of expression. Lawyers face reprisal for speaking out about the abuses they've seen. Lawyers have a front row seat to the rule of law. And so they provide crucial evidence when it breaks down. And I think we've already heard some examples of that today. They identify improper treatment of immigrants and asylum seekers. They defend human rights activists by asserting their internationally protected rights. And they defend journalists who may come under attack for exposing corruption or bringing forward important information that the public needs. Recent research demonstrates that lawyers who speak out in defense of the rights of others, including and often especially those who defend journalists and human rights defenders, are often themselves targeted with criminal charges, disbarment, and abusive lawsuits that seek to punish them for their work. Unfortunately, information suggests that strategic litigation against public participation, what are often called SLAPP suits, are on the rise in many regions. So let me be very clear. Lawyers have the right to freedom of expression, and I won't go back over the different legal standards since they've already been mentioned, and I want us to get to the Q&A, but it's important to recognize that these are protections that are set out in international law and clear international standards. So when there are restrictions on lawyers from fulfilling their legal duties to their clients, when bar associations are shut down or instrumentalized, states create this broader chilling effect. Seeing lawyers charged with crimes, detained, or worse, human rights defenders and journalists get a clear message. There will be no one to defend you when it's your turn in the dock. And this is why the report launched today by the Commonwealth Human Rights Initiative, the Commonwealth Journalists Association, and the Commonwealth Lawyers Association is so important. I'm so pleased and thankful that the authors have put in this hard work. And I'm also excited to soon see the report of the Law Society of England and Wales in its forthcoming report on the freedom of expression of lawyers. Before I close, I want to emphasize something that has already been mentioned, but to really ensure that we all keep in front of mind that there's a new tool available to help protect lawyers. The Council of Europe Convention for the Protection of the Profession of the Lawyer, often called the Luxembourg Convention, is filling a void by translating existing international standards into binding law, and it will be open to any state. States don't have to be members of the Council of Europe to ultimately become a party to this convention. Under the convention, states must guarantee that those who practice law can do so free of intimidation, obstacle, harassment, or interference. The new convention sets out and again echoes the important protection of lawyers' right to freedom of expression, both as individuals and as members of representative organizations like bar associations and law societies. The new convention is an innovative instrument. It will set up a comprehensive and bold monitoring mechanism, and I hope that we will all support this convention and engage with our states to ensure that they sign and become parties to it. Let me just briefly finish with some reflections on what we can do. Lawyers are strengthened and protected by their interaction and engagement with their peers and counterparts. I've personally seen this. I think we're seeing it today. Exchanging experience and stories and also strategies for how to deal with these difficult problems we're talking about is so important. And that means that we have to ensure the ability to access these discussions. I also want to say that I've seen bar associations set up important initiatives, such as the one run by the Barreau de Paris in France that has the Programme Répit, which is a program for people who are under threat, for lawyers who are under threat. And also I've seen really important initiatives by bar associations for those who are in exile. And so I hope that we'll all use our creativity to really support and ensure that folks who have to flee into exile have support, as well as those, of course, in situ. This event allows us to recommit to identifying, assessing, and taking action on the risks and obstacles that lawyers are facing when they exercise their freedom of expression. We have to face these challenges together. Brave lawyers need our support to continue their work. I call on all states across the world to positively consider becoming party to the Luxembourg Convention, and on bar associations and leading lawyers to help convince their own states to sign the convention. Those lawyers who step up into the public sphere to defend the rule of law and to protect journalists show us daily the path forward. The reports we're discussing today to provide a clear roadmap for protection. I hope that we'll take the next steps together, and I thank you so much for this opportunity to speak with you today. Back to you, Stephen. Thank you.
Thank you very much, Margaret, and thank you so much for bringing to attention the Luxembourg Convention, which is I think it's being mentioned and spoken about in many legal forums at the moment because it is a remarkable document. I think it's a product of 10 years of work by the CCBE, and congratulations to them for the marvelous work they've done. And we at the CLA, we are intent at actually getting our entire council to have this document brought to their individual governments and to encourage the governments to sign up. Because as you mentioned, it's just not confined to the EEC. It is open for signatories for countries outside, and I can't see why any country would not want to sign up. As you quite rightly point out, when the going gets tough, they will still need us in court. So it's good that they protect us and give us the protection that this document gives us. So I'm very happy that you've mentioned that. And I think it's good that you're here too, because I think the work of the UN Special Rapporteur is very important, but not always known or recognized. I think the lawyers among us must know that there is refuge and protection where all else fails within your own shores or your domestic circumstances. There is still the UN Special Rapporteur that you could go to and lodge a complaint and see what can be done as a measure of protection. So thank you very much, Margaret. Can we now move on to our last presenter today, last speaker, and that's William Horsley. William Horsley is a former BBC foreign correspondent and is here representing the Commonwealth Journalists Association, CJA. He's also a senior research fellow at the Institute of Commonwealth Studies and a professor of journalism at the University of Sheffield. This has been mentioned, and I'm sure William will refer to this, and that is the Commonwealth Principles on Freedom of Expression and the Role of the Media, which is a result of an 8-year campaign by the CJA in cooperation with CHRI and other Commonwealth organizations, which stands as a testament to his and his colleagues' commitment to advancing press freedom across the Commonwealth. Thank you very much, William.
Well, thank you very much indeed, Stephen, and sincere thanks to everyone who's organised this event. And I share your thoughts at the start, Stephen, that what we really need is to break the Commonwealth silence and bring it into the world conversation on these things. This is a first order issue to my mind, and the Commonwealth is behind the curve. I think we can agree on that between lawyers and journalists. 3 quick points from me, because I know time is short. The first, I want to say something rather shocking, perhaps. Sinead mentioned several of the key articles in the Commonwealth Principles on Freedom of Expression. There was another one on ending impunity, asking member states to take decisive action. And my conclusion for you today to chew on is that the sobering lesson from our report is that a creeping culture of impunity is taking over the Commonwealth, the opposite of justice and democratic accountability. So UNESCO says that in all, about 1 journalist every 5 days is killed in reprisal or to stop them from reporting. The figures regarding the Commonwealth are that well over 200 journalists have been killed in the last 20 years in 19 Commonwealth countries. And even more alarming, UNESCO has found that the rate of impunity for those killings is as high as 96%. That's much higher than even the shocking 85% that applies for journalists more globally. Couple of examples of the political background and the impact. The 2019 iconic case of the Tiger Eye journalist in Ghana, Ahmed Hussein Swale, who was shot dead outside his home after exposing deep and high-level corruption in the football establishment in Ghana. 6 years later, still no investigation, and the case appears to have gone cold. I do note that the Secretary General now comes from Ghana, and I think it's appropriate perhaps to speak about political leadership, because the alternative, if politicians and leaders don't speak out, is that this kind of thing simply goes on and gets swept aside. The second one I want to mention is the Daphne Caruana Galizia case in Malta, also an iconic case. She was also beset by more than 40 lawsuits, including by active politicians at the time she died. She was killed in a car bomb, remote-controlled explosion. The key there was an independent investigation actually was mounted, and they found that a culture of impunity had emanated from the office of the Prime Minister himself. Now, Malta has been chairing the CMAG, the Commonwealth Ministerial Action Group, only in July of this year. And again, I think it's fair for the populations of the Commonwealth to ask, why is it that the organization is unable to confront these abuses, root them out, and live up to its reputation as a champion of democratic norms, especially since in 2011, the mandate of the CMAG, the Ministerial Action Group, was expanded specifically with powers as strong as suspending member states for systematic or egregious constraints on civil society and media. So secondly, my second point is about legal intimidation and harassment, which other speakers have been very eloquent about. We do need a major drive by the Commonwealth institutions, that's the member states, the Secretariat, and ourselves, the civil society side, to roll back these laws. It's something that is in the DNA, it's in the masthead of the Commonwealth, but it's not being done. So more than 30 journalists, actually 10 of whom were unwilling to identify themselves in this report because of fear of reprisals, contributed their experiences. And in all Commonwealth countries, some of these journalists testified to serious concerns about the weaponization of law, having experienced it, laws on terrorism, defamation, cybercrime, and also interference in the media through overpowerful regulators, and we must repeal those kind of laws. To give some just statistics about the scale of this in some Commonwealth countries, in India, according to the book published by Amal Clooney last year, 15,000 cases of sedition were brought in India since the beginning of the Modi regime, creating obviously a chilling effect. And in Bangladesh, the number of cases which Professor Yunus, the acting head of government, says are now being probably groundless and are being looked at is 16,000. Quickly, in Kenya, in one day in August, more than 300 people on a pro-democracy protest were rounded up, many of them indiscriminately, and lawyers there say that there's an escalation in this misuse of law by the government to repress all kinds of dissent, with many people being charged, even if they're just bystanders, being charged, and some with terrorism and other offences, which mean that they can't get bail. And even in places like the UK, this report contains really useful recommendations for improvements in the law. For example, the really unexplainable omission in UK law of sufficient public interest defence in national security defamation and other cases. So, and the third point is, what can the Commonwealth do? The question you asked at the beginning, Stephen. It has to be a joint project, and the heads of government in Samoa did commit themselves to making concrete and meaningful measures to implement the principles in their domestic frameworks. The Commonwealth must now be held to that. The political culture of silence in the Commonwealth is standing in the way. There is no individual, no mechanism that regularly or at all speaks out against these abuses. And that can be corrected. There are examples from another non-treaty organization like the OSCE, Organization of Security and Cooperation in Europe, who 30 years ago created an office of a special representative on media freedom, so that there would be somebody who was free to speak out like that. The UN system of special rapporteurs is in parallel, of course. The Commonwealth does need something like that. One of our proposals in the report with SNE was for a Commonwealth envoy. But to me, the most important thing is that the institution itself, the Secretariat, needs to be rethought, needs to be reset, so that a number of officials there are detailed to take responsibility in this area, to listen to civil society, to allow monitoring, which they don't at the moment, and to gather the evidence and present it to the institutions that exist, whether it's a new envoy, whether it's the CMAG, and also to work closely, for example, with UNESCO on this issue of impunity, to make sure that Commonwealth states are no longer among the worst performers when it comes to responding to the requests for UNESCO for information about the investigations after the attacks and killings of journalists. So we do have one, the Commonwealth Journalists Association has put forward to the Secretariat and not heard back on one grassroots proposal. This is exactly in line with what the partners, the civil society, are supposed to do in the Commonwealth, something called the Pacific Commonwealth Media Initiative, which the media organizations and responsible people in 12 Pacific Island countries have suggested, under Lance Polu, the CIA's man in Samoa, to address these issues, to try to drive forward the reform of these criminal laws, which indeed there's one leading member of the journalist community in Samoa who is suffering from that right now because the law has not been repealed. And so I think that this kind of reform would give the Commonwealth a new sense of purpose. It is under attack by many quarters for irrelevance. The Times of London, even last September, spoke about the danger that the Commonwealth is perceived as a refuge for autocrats who want to avoid their obligations in this area. This is an imperative that the Commonwealth turns this round, and we must be doing it jointly, so let the dialogue begin. Thank you very much.
Thank you very much, William. That's a very good way to round up our initial presentations and the exhortation that we should come together and work together to achieve the common purpose, which we all agree upon. It's an important reminder. Now, we've got about 10 minutes, and I'm trying to actually give each of our panel members a chance to answer the questions. We've had questions that have been forwarded to us, and we have also questions in the chat. Can I first take Deborah, since Deborah, you're our first presenter just now. There is a question on Turkey, and can I just read the question to you? as it is in the chat box. Turkey example, in cases like the detention of the Turkish bar member for 4 months pre-trial, what does this say about the broader pattern of judicial harassment against defenders of free expression?
Yes, thank you, Stephen. The situation in Turkey is really dire for lawyers as well as also journalists and human rights defenders, although they're of course not alone in having a challenging situation for those types of groups who, just because they are the ones who are speaking out, trying to uphold rule of law, trying to ensure that access to justice is respected. I think what we see in Turkey and also in other countries is where you have laws that are vague and overboard, which we've heard today, they are then very much open to misuse. But when you then have a lack of independence of the judiciary, that creates the perfect recipe for lawyers, journalists, human rights defenders to be targeted for their freedom of expression, for anyone to be targeted for their freedom of expression. So that is a concern. And that's something that certainly the Law Society and other organisations, along with the UN Special Rapporteur on the independence of judges and lawyers, try and promote, is the importance of an independent judiciary. They hold also a very key role in ensuring that laws that perhaps are badly written, that are then being tried to be misapplied, are not actually then used. So I think when you see that sort of perfect recipe, it is a concern, and that's what we're seeing in Turkey. That's what we're seeing in other countries as well through our Lawyers at Risk work. And so certainly those lawyers, those journalists, those human rights defenders who are speaking out against abuses of power find themselves in the firing line. So that's why it's very important to also be speaking about the importance of an independent legal profession and an independent judiciary as well within this context. Thank you.
Thank you very much, Deborah. Sinead, there's a question for you, and this is from Canada. Can I just read the question? The speakers are often quoting and referencing human rights legislation and principles to defend the rule of law and freedom of expression. Many of these were adopted over 60 years ago, and even the newer legislation and principles are founded upon these earlier principles. Ms. Aurora suggests suggests using existing laws and principles to hold governments to account. But in today's world, populist governments offend the rule of law, distance themselves from those principles. Populist governments who offend the rule of law, distance themselves from those principles, and even disparage them as woke, and contrary to their supporters largely largely with impunity. Can you share any practical alternatives to using laws and institutions that are faltering and being discredited to protect the rule of law and the freedom of expression? Say that could be a separate webinar in itself, but in 2 minutes.
Yeah, indeed it could be. And thank you for that thoughtful and very important question, Darcy, from my own country, Canada. You're absolutely right to point out the tension that we're seeing globally, that the increasing disconnect between the universal human rights principles and the reality of populist majoritarian governance, where even foundational rights are dismissed as being foreign or as woke. And yet that's precisely why these legal frameworks, however old they are, still matter. They provide a baseline of accountability, and even when governments try to ignore or undermine them, they continue to serve as tools for mobilization, for resistance and record keeping. That said, I agree that law alone is not enough sometimes, especially when institutions are weak or co-opted. So we must think legally, politically, and adopt a range of practical alternatives, strategic alternatives, including building alliances beyond the legal field. So, for example, lawyers, journalists, artists, community organizers need to work together. The narratives matter. If legal principles are being discredited, then we must reframe them in ways that speak to local realities and identities. We can also use community-driven monitoring and pressure, using, even where the courts falter, evidence-based advocacy is so important, especially when grounded in lived experience. It can create political costs for rights violations. Local and international documentation helps sustain memory and momentum. I think also strategic litigation still matters. You can leverage international solidarity. Regional and global networks still play a key role. Governments may dismiss human rights bodies, but many still care about trade, diplomacy, image, reputation, and using those pressure points strategically can still be effective. And of course, protecting and strengthening independent journalism. So when formal accountability breaks down, journalism often becomes the last line of defense. So supporting media freedom is not just about content, but it's important to ensure that people can ask questions without fear. So I think when laws and institutions falter, we don't discard them, we use them alongside other strategies, and we adapt and we translate, we connect, we resist.
Sinead, thank you very, very much. Kevin, there's a question for you from Hong Kong, all right? And it reads, is not threatening judges in general, so the question does assume that you have threatened a judge or number of judges, who have no control of the cases that come before them in a well-respected judicial system, a breach of the Luxembourg Convention, the convention that Margaret mentioned just now, or the CLA Goa Declaration, which I must inform you is a declaration that we passed at our conference in Goa now, 3 years ago, and where it's essentially a declaration on the independence of the judiciary and the independence of the legal profession. Yeah. Okay.
Sure. Thank you, Stephen. And I know the Law Society Council member who asked that question, and I say hi to him as well. It's been a long time. And I would respond to this question in a number of ways. Firstly, I do not believe that I have engaged in conduct that was threatening any judge for that in that sense. All that I'm asking is that the Hong Kong legal system operates as it should in accordance with the rule of law. And might I say that my concerns about the Hong Kong judiciary, not only did I have lots of footnoted references in my written submissions on my specific concerns over specific incidents, but I would note firstly that in a 2022 Hong Kong Law Journal article, the former dean of University of Hong Kong Law School, Johannes Chan, said this about the Hong Kong judiciary, that it displayed excessive deference to the sovereign, I'm quoting here, endorsement and legitimization of the draconian measures on national security, and active suppression of fundamental democratic values in national security cases. And I might also add that a former Court of Final Appeal non-permanent justice, Lord Sumption, said this about the Hong Kong judiciary. I quote, intimidated or convinced by the darkening political mood, many judges have lost sight of their traditional role as defenders of the liberty of the subject, even when the law allows it, unquote. So I do not believe that my views are in any way an isolated or an uncalled for view. There are people much more considered than I am who have expressed much more strident views than I have on this issue. And I might also add that if the Law Society of Hong Kong has such concerns about those issues, where were they when over many years pro-Beijing voices and even voices from the Central People's government in China have made noises about judicial rulings, have threatened various things against judges, and so on. I mean, where were they on that? Yeah, a little bit of consistency would be nice, I would respectfully submit.
Thanks, Kevin. Thank you so much. We are running out of time, but there are one or two other interesting questions. And in fairness to our panel members, can I pose this question to Neha? Neha, this is a question that I think has come from India. When mainstream newspapers are unable to put out the truth, which is unfavorable to the government in power, what options are available to the brave journalists like yourself?
Thank you for that question. I just want to say, like, bravery is not there's no option but to be brave for most journalists, not just me. And I would say that I'm still not in jail, but I'll give you two examples. One is the fact that internet has in some way democratized the media, so which means that a lot of power that mainstream organizations had, they no longer have it. And I'll explain with an example. Recently, 2 years back, I was covering some elections in North India in a village, and an old person called me and he asked me if I'm a YouTuber. And I said, no, I am not. I'm a journalist. And then that person responded and said, then I will not speak to you. And this says that journalists have completely lost credibility in most parts of the country, and people are trusting YouTube and YouTubers. I mean, we can get into details of whether what is authentic, what is verified, has due diligence been done or not. That is there, but people are finding ways to put out truth, and once you put it out online, there's no way that it won't reach people, and it won't. People are not going to take cognizance. The other thing I want to say, another example I would say, is that the example of journalists in Kashmir. In 2019, India, Kashmir has been a conflict zone forever. In 2019, India basically stripped Kashmir of its special status. And after that, there has been a lot of protest, and after that, COVID followed, which meant that there was no internet supply was cut down. And in the world that we live in today, what kind of reporting can you do when there's no access to internet or even phone networks for that matter? And in those situations, I do want to say that Kashmiri journalists who were committed to journalism, what they used to do was put all their reports in hard drives, flash drives, pool in money, buy tickets for one person who would get all those flash drives to Delhi, and then disseminate news. So people who are committed to it in some way find ways, and people have been doing that.
Thank you very much, Neha. One last question, but this question goes to both our final two speakers, that is Margaret and William. And this is one of the advanced questions that was sent to us. It's a very general question, but I think it'll afford an opportunity for both of you to say something about this. An African leader once said, quote, "There is freedom of expression, but what he can't guarantee is freedom after expression." With this in mind, what will be the modalities to be adopted to disabuse the minds of these leaders in the cause of defending the freedom of expression for lawyers and journalists? Margaret?
Thanks so much. I know it's an outstanding quote. I think what I would say is the recognition by the public that freedom of speech by journalists and lawyers is protecting them. So, we've been focusing a lot on the rights of the individuals who are directly targeted, which is absolutely right. But I think we have to recognize when lawyers are protecting the rule of law, when journalists are speaking truth to power, that's actually helping all of us. So redefining it in that way and ensuring that the public supports these things, I think will go a long way. Back to you, Stephen.
Thank you, Margaret. William? You're muted, William. You need to unmute.
Sorry, I've just muted myself. I think your speaker really puts his finger on the problem. There's a coalition of interest now between the super powerful in politics and the surrounding powerful in terms of business and the tech companies and control of the main area for our mutual communication now, many to many and of all kinds, and that is the internet. And of course, the misuse of digital laws, cyber laws, and so on is now the front end, surveillance and so on. The latest UN Human Rights Council resolution on the safety of journalists, an issue of impunity. There's been one every single year or more since 2012, when this rose up the UN agenda in recognition of this problem. So I would say in brief, the UN, my experience is that the UN, UNESCO, the Geneva part of the UN, the Council of Europe, the OSCE, the African Union, everywhere where there are these regional organizations and so on, they serve, and courts particularly, they serve an immensely important role as a safety net, and often even making new laws. After all, there have been repeals of laws in Commonwealth countries, these criminal laws which are so offensive. So we, like other speakers have said, we have to believe, and to get the public on side, I'm afraid the only answer is integrity and truthfulness, and win support by high quality. And for that, we really do need support from public and state institutions. Often it's not there.
Thank you, William. Now with that, I need to draw this webinar to an end. On your behalf, participants, may I thank our eminent and distinguished panel members for their very good presentations this evening here in Malaysia. And I'm sure it has been edifying. And if we had any doubts that freedom of expression is under threat, whether for lawyers or journalists or generally, I think that doubt is manifest today from what we have seen and what we have heard. There are many lessons to be taken away from this webinar. We must strengthen our resolve to hold on to this freedom. We must be alert to the erosion of this freedom that is around us, subtly and not so subtly sometimes. And I think that it's important that now we have two very important documents that are coming about, which I believe will assist us in our advocacy. We thank you. We want to thank our persons who are on the ground, who have actually been at the brunt of a punishment, if you like, for exercising this universal right. Kevin and Neha, thank you very much for sharing that. And you have our support in this journey. Please keep up the work that you do. And that's a message to all of us here, advocates for freedom of expression. Thank you very much again. And I wish you a good evening, a good day. Thank you. Bye-bye.